Welcome to the fourth and final panel in the Originalism Symposium of 2023. This one is titled The Second Amendment After Bruen, the Relationship Between Originalism, History, and Tradition. In New York State Rifle and Pistol Association versus Bruen, decided last summer, the Supreme Court held that New York's firearm licensing regime violated the Second Amendment's protection of the right to keep and bear arms. Writing for the court, Justice Thomas announced a two-part test for resolving Second Amendment cases. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. The opinion raised several methodological questions, many of which were cataloged in a concurring opinion by Justice Barrett. Those questions include, how long after ratification may subsequent practice illuminate original public meaning? And may practice settle the meaning of individual rights as well as structural provisions, as well as should courts primarily rely on the prevailing understanding of an individual right when the 14th Amendment was ratified in 1868 or when the Bill of Rights was ratified in 1791. At bottom, these questions urge us to consider the relationship between history and tradition on the one hand and originalism on the other. We're fortunate to be joined by two panelists who have thought deeply about these questions. Professor Robert Leider is an assistant professor of law at Antonin Scalia Law School, George Mason University. His scholarly interests are in criminal law, criminal procedure, and constitutional law, especially concerning questions about the use of force and the rule of law. Before joining Antonin Scalia Law School, Professor Leider was at Arnold and Porter in Washington, D.C. He was previously with Mayor Bruen and was an Olin Sear Smith Fellow at the University of Pennsylvania Law School. He has clerked for Judge Diane S. Sykes of the U.S. Court of Appeals for the Seventh Circuit and Justice Clarence Thomas. Professor Leider earned a B.A. summa cum laude from George Washington University, a J.D. from Yale Law School, and a Ph.D. in philosophy from Georgetown University. While at Yale, he served as an articles editor for the Yale Law Journal. Professor Mark W. Smith is a visiting fellow in pharmaceutical public policy and law in the Department of Pharmacology at the University of Oxford, presidential scholar, and a senior fellow in law and public policy at the King's College, and a distinguished scholar and senior fellow of law and public policy at the Ave Maria School of Law. He is a constitutional attorney and host of the Four Boxes Diner YouTube channel, which provides scholarly and historical analyses of the Second Amendment. Professor Smith is also a New York Times bestselling author. He is a graduate of the NYU School of Law and the University of South Carolina, where he earned a BA in economics. Before becoming an academic, Professor Smith worked as a law clerk to a federal district court judge, was associated with Skadden Arps, was a partner at Kasowitz, Benson, Torres, and Friedman, and founded his own litigation boutique with offices at Rockefeller Plaza, Madison Avenue, and Times Square. We're going to begin with Professor Leider.
All right, thank you very much, and thank you for having me here. So I want to talk a little bit about Bruen and Bruen's relationship to constitutional text on the one hand and history and tradition on the other. And the central claim in my presentation is going to be that Bruen follows what I will call a general law approach. And by general law, I mean the very thing that Erie versus Tompkins denied existed. So my remarks are going to follow on a scholarship that's been coming out from Judd Campbell, Will Bode, and Steve Sachs on the nature of general law. And I think the Second Amendment protects the right to keep and bear arms. That is a right that was protected by general law, by traditional English law. And I think Bruen recognizes it as a general law right and looks to the general law for the limits and how to regulate the right. And that will lead to a series of, I think, methodological questions that I will come to at the end. All right. So let me start off the bat by discussing what Bruen held and what Bruen did not hold. So Bruen held that there was some right to carry common arms in public for self-defense, and Bruen held that the legislature could regulate the right in the public interest, but the regulation could not amount to a denial of the right. And Bruen, on the flip side, did not hold that there was a right specifically to carry a concealed weapon, even though a lot of jurisdictions are treating it today as if it held that. But Bruen does not say that. It says there is a right to carry in public, and legislatures can choose how they want to regulate the right. And correlatively, Bruen does not say that the right is unlimited and beyond any regulation at all. And so coming out of Bruen, a lot of the questions are going to be, when can you regulate the right? How, in what places? All right. So the first thing Bruen does is Bruen rejects the tiers of scrutiny that was prevailing in the circuit courts after Heller was decided. So once Heller came down, the circuit courts engaged in what UVA's Professor Ray would call narrowing from below. And they did this first they kind of fell into this. They did it initially by establishing a two-tier framework. And first they asked, is the conduct at issue within the Second Amendment? And if it wasn't, then the challenge failed. But if it was, they went to the second claim, which they asked, well, was it at the very core of the right? And the only thing they ever recognized at the very core of the right was the right of a perfectly law-abiding citizen to have a handgun in his home for self-defense. And so that's the one thing Heller says you can't ban. And so that's the one thing they might have applied strict scrutiny to. It was never clear, but everything else got intermediate scrutiny. And what they called intermediate scrutiny really wasn't. It was a rational basis review doctored up as intermediate scrutiny. And, they made a few problems with the analysis. One was watering down the standard of review beyond recognition. Intermediate scrutiny is the kind of scrutiny that we apply to claims like sex discrimination. And, in U.S. Versus Virginia, Justice Ginsburg, writing for the court, said that it's the kind of scrutiny that requires an extremely persuasive justification. But that was not the kind of justification that courts were requiring. Judge Easterbrook in the Seventh Circuit upheld an assault weapons ban in the city of Highland Park as long as it would make people feel safer. So, that was one issue. And the second issue was they were making everything within the scope of the right. So the Third Circuit, which is one of the first courts to deal with claims after Heller, applied intermediate scrutiny to a federal prohibition against possessing a firearm with a defaced serial number. And the problem was, once things like, a gun with a defaced serial number is particularly adapted to criminal purposes. It has no real lawful use. But once you bring everything and say, well, the Second Amendment is triggered, it became much easier on the back end to start watering down the standard of review to sort of rationalize why all these regulations were constitutional. They were not doing a very good job gatekeeping up front and saying, well, some of this may just be conduct that's not within the scope of the Second Amendment. And the Supreme Court got into a position where the tests that had been applied in the lower courts had become ungovernable, and they wanted to sweep it away and replace it with something else. And what did they replace it with? They replaced it with a text, history, and tradition test. And so, here comes the theme of this lecture of, what is the relationship between text, history, and tradition and originalism? And I think that what the court is getting at here is this idea that there is general law and that courts should apply it. So let's start with the text of the Second Amendment. The text of the Second Amendment does not say we are creating a right to keep and bear arms. It says that the right to keep and bear arms shall not be infringed. The Second Amendment protects a pre-existing right. And where does this right come from? It comes from traditional general law. And so we have to look at traditional general law to determine the scope of the right. So, it's important here to note that the Second Amendment is not a nationally created right. The Second Amendment secured the right against the federal government, but it did not create the right. If it had created the right would have been directly applicable against the states under the Supremacy Clause. There would have been a federal cause of action long before 1868 for its violation. So the Second Amendment does not create a right to bear arms, which is why, in Barron versus Baltimore, the court says that the Fifth Amendment and those provisions of the Bill of Rights, which secure rights, do not apply against the states. All right, so if the right is pre-existing, where did it come from? And my answer again, general law. So the thing that Erie says doesn't exist. And this is why many states which applied a right to bear arms against the state did so using their own state constitutional provisions under the theory that their own state constitutional provisions were coextensive with the Second Amendment. So what you see in state court decisions in the 19th century is this idea that we have a general law right to bear arms. The Second Amendment secures it against the federal government, And either general law or a state constitutional provision secures it against state interference. And so, states had slightly different language in their right to bear arms provisions. But one of the things that's notable is that the state Supreme Courts tried to interpret the right uniformly. They tried to figure out what the same general law right is. They never went to the exact language of their texts and say, well, we're bound by the exact verbiage that's in our state constitution. No, what they said is this right is codifying the right that existed at general law. All right, and so for evidence of the general law reading in Bruen, you have to look at how the court analyzed the claim. So first of all, it looked to general principles of law. It applied general law principles that existed across jurisdictions. So when the court said the right to bear arms includes a general right to carry arms outside one's home, it was applying a law that had developed in the 19th century and for which there was some treatises in the 18th century that also confirmed its existence. And you see the court looking at different decisions from different states and saying most of them recognize this right. You also see the court saying that a few states don't recognize this right, but we think it's wrong. We think those decisions are wrong. And what I think methodologically the court is doing is saying that there is general law here. We're not going to be nihilists about general law. We recognize that different courts and different jurisdictions may have different opinions about what the general law is, but we have a general consensus that the right to bear arms included the ability to carry arms outside the home. And we recognize that there are a few outlier decisions, but we think these decisions wrongly stated the law. And so what you have there is, I think, a different perspective from how it's being portrayed by some gun control advocates today, of the court looking at different law and just picking among its friends. I don't think it's picking among its friends. I think it's looking for a consensus of what the law is, even if state courts were not unanimously, even if state courts were not unanimous on exactly what the law was. Now, with that, I think the court had an easy time applying general law here. People like to say, well, the Second Amendment is this blank slate and we don't know what's in there. And that's total nonsense. We have hundreds of years of litigation in state courts on the right to bear arms. And Bruen was within the core issue that was most litigated in state courts on this subject. There were no assault weapon bans in the 19th century. There were some laws against personal weapons like knives. But for the most part, the number one issue that state courts adjudicated was how far could a state go in restricting the carrying of weapons outside the home. And so Bruen here is, this is an easy place to apply general law because there was a lot of general law for the court to draw from. Now, the question is, if this is general law, one of the difficult methodological questions is, if you're applying general law, what general law do you apply? Because general law, as a form of common law, changes over time. Do you apply the general law as it existed in 1791, 1868, or today? And one of the difficulties with Bruen is it gives a yes to that question. You see Bruen at times applying all three sets of general law. You see the 1791, you see a lot of claims of we're going to apply 1791, and this is traditionally how we do rights. And Professor Smith has written about this in his Harvard Journal of Law and Public Policy article that, traditionally the court has looked to one-tier incorporation. But that's not entirely what the court actually does. One of the things the court says is, well, you can regulate the manner of bearing arms, and it draws from state court cases restricting the carrying of concealed weapons. Those cases didn't exist in 1791. That was how the right to bear arms liquidated in state courts between our separation from England and the ratification of the 14th Amendment in 1868. And so you see the court in part drawing from that body of law, which was not firmly established in 1791. And then you see this third thing where the court is drawing from kind of modern general law without much explanation. So it says, the court says, for example, well, you can have a licensing system as long as it's a shall issue licensing system. Well, there are no examples of courts upholding licensing regimes in the 19th century for carrying arms outside the home, except for slaves and free blacks. And that was done under the theory that they were not entitled to the full protection of the Bill of Rights. And what you have in modern shall issue regimes is you have a traditional Second Amendment analysis intersecting with the modern administrative state, which engages in a lot of ex ante licensing of conduct. And the court says this is okay. Court also repeats its assurances on bans on felons possessing guns, even though such bans did not exist in the 19th century. And the court, in an interesting twist, says states can regulate the manner of bearing arms, and they can pick open or concealed carry as long as they allow one or the other. But if you read the 19th century cases closely, they don't say that. They say that the right to bear arms is the right to bear them openly, because it included both bearing arms for personal self-defense and bearing arms for military purposes. And if you had to bear a long gun, it would necessarily not be concealed. So concealed weapons were always treated for the Second Amendment as the analog of obscenity that obscenity is for the First. It was never that states could pick one or the other. That is sort of a modern gloss on a historical regulatory tradition. And, there is a question here of whether what the court is doing is legitimate. And should we be looking, as Justice Barrett said, to 1868? Well, that question is a very difficult one. The Bruen is actually a 14th Amendment case, as Justice Thomas noted. It is not a Second Amendment case. And the right to bear arms applies against the states because of the Privileges and Immunities Clause, at least for those committed to original meeting. But the Privileges and Immunities Clause, the 14th Amendment does not say that the Bill of Rights as such is applicable against the states. What it said is the privileges and immunities, it protected the privileges and immunities of citizens of the United States and said that no state shall deprive them. And so if you're being strictly originalist about this, I think there is a very legitimate question about whether you look at 1791 or if you ask what were the privileges and immunities of citizens, those rights at general law that existed at the time that the 14th Amendment was adopted. And I think there is a strong argument that you do go to 1868 because, again, the Privileges and Immunities Clause is not by words incorporating the Bill of Rights. What it is what it's doing is it's giving a federal cause of action to the violation of general law rights. And I'm running a bit low on time, but let me just do a couple of last quick notes here. The Bruen test is coming under a lot of flack on the view that we can't engage in this sort of historical analogy approach. And I think how Bruen is being interpreted in the lower courts is a mistake. Bruen never says you have to find an exact analog and then incorporate it to modern day. Bruen says you reason from analogy. And I think what is going on here is what Bruen is saying is that we apply the traditional 19th century mode of regulating rights. So you can regulate, in the 19th century, they would recognize rights, and then they would recognize that there was a police power to regulate the rights. And the police power you could exercise the police power, for example, to prevent somebody from using their rights to infringe the rights of others. But you couldn't exercise the police power just to snuff out the core of the right. But the court is not speaking in the language of the police power, probably doesn't have a theory of the police power. And I think part of the problem is that even though you have broad agreement among the justices that the Second Amendment is an individual right, I don't think you have a broad agreement about what the right actually, why the right is actually important and what it's designed to protect. Whether it's just strictly individual self-defense against crime, or it also has this additional military-related component. I don't think they have a consensus on that. And the areas where a strict historical test will work well are cases like Bruen, where you have a lot of general law to draw from. And that's why the Carey cases, I think, are somewhat easy on a strict historical test. The area where the historical test will not work well are cases where the court has to develop new general law, reasoning from analogy from the old law, because you have new problems like, can Congress regulate the carrying of weapons aboard commercial aircraft? Or, what do you do about machine guns and the like? And so I think this is one area where the historical test is going to break down and where the court is going to have to reason more traditionally from looking at the text and the purpose and of the Second Amendment and then reasoning from analogy there. And I think ultimately what will happen, I do think that the lower courts will engage in pervasive narrowing from below. I think the right to bear arms remains a disfavored right. And I think, how robust Bruen is will ultimately come down to how aggressive the Supreme Court is in defending its judgment.
Thank you, Professor Leider. Professor Smith?
Professor Leider always makes excellent points, and I always appreciate his scholarship. I'm going to approach this question about originalism and the Second Amendment a little bit more from a practical courtroom experience, because that's a little bit more consistent with my background. But I do want to make three general observations and then get into each. The first is that Bruen is an originalist case. The second thing is it's extremely important that the Second Amendment jurisprudence succeed in light of what's going on. And last but not least, I want to talk about how you actually apply what I consider to be a very easy approach to the Heller-Bruen methodology, which I don't think is particularly difficult. So my first point is that the Heller-Bruen decisions, and they do go together because really, although we're referring to all this as the Bruen methodology of text and history and tradition, the reality is it's not really the Bruen methodology. What it really is the Heller methodology that introduced and talked about the importance of text, history, and tradition for originalism and interpreting the Second Amendment. It's just that now we're talking about Bruen because it's the latest thing. And frankly, Bruen, because of what was really lower court misbehavior, if you will, the Bruen court had to really lay things out in a much more detailed way than it did in Heller, because they were speaking to a lot of the misconduct, if you will, that was going on in the 10 years between Heller and Bruen. So really, the Bruen methodology is really the Heller methodology, and the Heller methodology is absolutely originalist because it says you start with the text of the Second Amendment, and there is no more fundamental starting point for an originalist than to start with the product, the outcome of the process that gave rise to the ratification of the Constitution, including the 1791 Second Amendment and the rest of the Bill of Rights. So certainly Bruen's attempt to interpret the text of the Second Amendment and then giving the government an opportunity to present history, a tradition or regulation we'll get to in a second, to kind of discuss more about the scope of the Second Amendment is very much an originalist endeavor. Now, this is very important for my second point. The discussion of originalism has been going on for many decades at this point, going back to really the founding of the Federalist Society, if you will. So this multi-decade experiment, discussion, gestalt involving originalism if you try to do originalism, which the courts certainly do try to do, as Judge Kagan once said in her confirmation hearings, we are all originalists at this point. So, but the problem is, if you try to do a pure originalism analysis of the First Amendment, of the Fourth Amendment, of the Fifth Amendment, of the Takings Clause, the issue is you, as a practical matter, as a judge or as a Supreme Court justice, you start to bump into barnacles. You start to bump up against the tiers of scrutiny barnacles that came about over the last, multiple decades of arguably liberal judicial activism. You start having to reason around precedents that really ought not be there because they're not there by virtue of originalism. But that is not the case when you're interpreting and applying the Second Amendment, which has not been burdened by the liberal judicial activism precedents that we saw in the 60s and the 70s and to some degree in the 80s. So again, if the originalist experiment cannot work in the context of the Second Amendment, then it cannot work for any other aspect of the Constitution. So that's why I think this is a very important process and an important topic that Professor Leider is looking at as part of his scholarship and as we're talking about today as part of this panel. Now, let's talk about the actual methodology that Heller and Bruen together, you have to interpret them together, set forth. And I actually think it's a very straightforward process. The Supreme Court starts off and says, you start with the plain text of the Second Amendment. I don't think there's a lot of ambiguity there. The Supreme Court certainly doesn't seem to suggest there is, because if you look at Heller, it literally defined every term in the Second Amendment. It defines the people as essentially all Americans. It defines the right to keep as the right to have, to possess, the right to bear, the right to carry guns or carry weapons outside the home for the purposes of self-defense. So it seems to me that if you look at the text of the Second Amendment as interpreted by the Supreme Court, the definitions are all there and they're founded in history. For example, the Supreme Court in Heller quotes and cites to things like Samuel Johnson's famous dictionary that was in use at the time of the founding. So then you have the text of the Second Amendment is clear as I see it. Then, of course, you have the other aspect of the text, which are those things that come into play by necessary implication. That is, although the text of the Second Amendment doesn't refer to ammunition, although the text of the Second Amendment doesn't refer to magazines, although the text of the Second Amendment does not specifically refer to training or any of these things, courts have said that these are, necessarily implicated in the context of the Second Amendment, no different than, for example, the right to meet with a client in confidence or privately in a prison is implicitly part of the right to counsel under the Sixth Amendment. Or, for example, the right to have ink, the right to have access to an internet, the right to have access to paper, and the right to be able to buy a printing press are all necessarily implicated by the right of free speech and the right of free press under the First Amendment. So you have the plain text as defined by the Supreme Court, and then you have other things that are necessarily implicated, which I've just discussed, which is a traditional way you interpret the Bill of Rights, among other aspects of the Constitution. So once you get to that, now we get to the rub of the question of this panel, which is what exactly now is the role of history and what is the role of tradition? Well, the answer before Bruen, as I used to argue it or discuss it, was the following. And then I'll talk about where we are today in light of the Bruen decision. The way I used to interpret history and tradition was, you look at the history of the Second Amendment, and then that was basically at the time of the founding. And tradition was what happened in the 19th century, which can serve as what I would call a confirmatory analytic, which means that if you have 19th century history that corroborates the 1791 understanding, that can be considered and that is relevant. But if you have 19th century history that is inconsistent with the 1791 understanding or the 1791 text of the Second Amendment, then you have to discount it, which most recently, by the way, we saw by the U.S. Supreme Court in 2020 in a slightly different context involving the First Amendment. We saw in 2020 the Supreme Court decided the Espinoza versus Montana Department of Revenue decision. And in that case, that was a situation that interpreted the First Amendment's right to free exercise of religion. And in that case out of Montana, there was a specific state statute that barred, I won't get into the specific details of the case. The bottom line is that under the Montana laws, religious private schools were treated less well than non-religious private schools. And the religious schools in Montana sued under the First Amendment's exercise clause, saying that we are being discriminated against, and this violates the First Amendment. And if you look very carefully at the decision of Espinoza, this is very telling. Even though it's in the First Amendment context, it really speaks to, I think, where this court is at mentally, because the decision in Espinoza was written by Chief Justice John Roberts. And what Chief Justice John Roberts said is, you look basically at the time of the founding to understand the scope of the First Amendment. And then Montana, by the way, brought forth 30, I repeat, 30, that's 30 different state laws that were enacted in the late 19th century that said that you basically could discriminate and by not using public money to go to religious schools. And in Espinoza, the Supreme Court specifically said that the fact that Montana came forth with 30 late 19th century state laws that in their view discriminated against Catholics, that's what the impetus was, so the Supreme Court said, that was not a basis for overriding the original meaning of the 1791 First Amendment. So when it comes to the Second Amendment, I think metaphorically or analogously, it's the same concept. The late 19th century evidence that contradicts the text of the Second Amendment or understanding the Second Amendment in 1791 cannot override or contradict or undercut that 1791 right. At most, late 19th century laws can confirm the 1791 understanding. It's a one-way ratchet. But let me continue. Now, you have the plain text, and once the modern day gun control law is implicated by the plain text, what happens? Well, there's two things that happen. The burden shifts to the government in the same way that when you walk into a criminal court, you are presumed innocent. In the context of the Second Amendment, the Supreme Court has said that if a modern day gun control law is implicated by the Second Amendment or whatnot, the Second Amendment is triggered by a modern day gun control law because it affects the right to keep and bear arms, the burden immediately shifts to the government to justify it. And the law is presumptively, I repeat, presumptively unconstitutional. No different than when you go into a criminal court, you are presumed innocent. So the burden becomes entirely upon the government. And this is extremely important. That's the procedural posture of what happens when the Second Amendment is triggered by a modern day gun control. Now, the second part, the substantive part, is extremely important when you combine it with the procedural, because once the burden shifts to the government to demonstrate that a modern day gun control law is constitutional, the burden is entirely on the government. And if the government cannot demonstrate that modern day gun control law is consistent with the Second Amendment, they lose. It doesn't matter why they can't meet their burden. If they cannot meet their burden for any reason, they lose. I draw the analogy to a criminal case. If you go into a criminal court, you've been accused of a crime, the burden shifts to the government. They have the burden to come forth with beyond a reasonable doubt evidence that you've committed a crime. It doesn't matter why the government cannot prove their case. If they have bad lawyers, it doesn't matter, they lose. If they can't find the murder weapon, it doesn't matter, they lose. If they lose a witness, if a witness moves out of town and they can't prove their case, it doesn't matter, the government loses. I think the same concept applies here, because the Supreme Court made it very clear in Leider and Bruen, if the government cannot meet its burden, the government loses. Now, this is particularly true if you look at footnote 11 of Bruen, which talks about how to interpret the Sir John Knight's case. There was a long discussion of a case that the anti-gun community was trying to use to cut down on our right to keep and bear arms. It was the Sir John Knight's case from jolly old England. I won't bore you with the details, but the bottom line is, countless volumes of books and articles were spilled on what was the meaning of the Sir John Knight's case. Did it mean that, that government could restrict the right to carry weapons, or did it mean that you could only restrict the use of weapons to go about terrorizing the countryside or terrorizing the people? The pro-gun view was the Sir John Knight's case stood for the proposition that you could not misuse firearms to terrorize people. The anti-gun position on Sir John Knight was it proves that they can regulate just general carriage of firearms all across, the country or in public. The Supreme Court in footnote 11, after distinguishing Sir John Knight's can find it unpersuasive for the anti-gun side, they did go on to say at the bottom of footnote 11 in Bruen the following. They says, to the extent there is any ambiguity about how to interpret the Sir John Knight's case, we, the Supreme Court, opt to presume and defer to the interpretation of the Sir John Knight's case most consistent with the Second Amendment's command. To me, I read footnote 11 of Bruen very specifically that says that if the government cannot come forth with a clear proof, and we're going to get to what that proof is in a second, then they lose. And that's what footnote 11 says. When in doubt, freedom prevails, the fundamental right to keep and bear arms prevails, and the government loses. So what exactly does the government have to prove, and how does this play a role with history and with tradition? And I think it's actually quite simple. The way to understand it is once the plain text is implicated, the burden shifts to the government has to do the following. The government bears the burden to review history. The process that they have to undertake is a historical survey, a historical review. What they're not allowed to do, and this reason why this is so important, as Professor Leider articulately pointed out, was that the destruction and the end of tiers of scrutiny, which is a euphemism, by the way, for allowing judges to balance away your rights in the name of some government interest. So tiers of scrutiny is clearly, kicked out the door. It was, I think it was kicked out the door in Heller, but was certainly kicked out the door now in Bruen, and in its replace was a historical review. Now, so we know that instead of tiers of scrutiny, the government has to come forth and do a historical review. That is the methodology, the process they must use. Now, with that said, what exactly is the government looking for when they conduct that historical review, which they're obligated to do to the extent the Second Amendment language is triggered by a modern-day gun control law? The answer is found in the holding of Bruen itself, specifically that the government has to survey history and find, if they can, a tradition of regulating firearms in the same manner, the how and the why, if you will, of modern-day gun control law. This is the holding from Bruen. You don't have to trust me. You can trust the holding of Bruen. This is what it said, quote, "In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. To justify its regulation," this is the key part, and then I'll wrap up, "the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation." And the only point I will make to that is when you're talking about firearm regulation, you're actually talking about actual enacted laws that were enforceable by law, and not some sort of theoretical concept that some of the anti-gunners want to talk about. They have to come forth with a tradition of actual laws. And the one example I would say, and then I'll wrap up, that I think prove that the government can show is a longstanding tradition of law that regulates firearms is the misuse of firearms, for example, to commit murder or robbery, to the extent, you know, you're not allowed, there's a law that bans you from using a gun today to commit a robbery or a murder. Today, you go back to the time of the founding, that law, meaning you could not misuse firearms, has existed since not just the founding, but even before the founding. That would be a very easy example for the government to find that longstanding tradition of firearms regulation is constitutional, even though it's not specifically in the text of the Second Amendment. And look forward to continue the conversation and answering any questions.
Great. Thank you, Professor Smith and Professor Leider. So I want to begin kind of a moderated discussion here. And I'm going to start with a question for Professor Leider. So what do you make of Professor Smith's burden shifting argument? He seems to argue that it's on the government to rebut a presumption, namely that there are historical analogs to the regulation that the government's defending. You seem to argue that the historical evidence makes up the content of a general law Second Amendment right. It would seem then that the challenger would have the burden then of proving the negative. Is that true? And if so, is that consistent with Bruen?
I think we have to be careful here in treating the historical tradition as a fact to be proven at trial. What the right consists of, I think, is a question of law. It is a question of law committed to the court. And I think treating it as a factual question is a pretty dangerous thing to do. Because if you start treating it as a factual question, you can have a situation where, you know, the government produces some evidence in one case, but not enough, and the court upholds the law, only to come back in a subsequent case with different parties and say, you know what, we found a lot more evidence, let's change the law. And I don't think the law should be that contingent on party presentation of evidence. I think what the court is saying that judges have to do is they have to look at the nation's historical tradition of firearm regulation. I think what that means is that they should consult the general law sources on how and when the police power could be exercised to regulate the right, and to reason from analogy, as good common law judges do, to modern problems. And I think, you know, that method is a pure question of law. That is something judges can do. Judges can rely on, and should rely on the evidence before them in the briefs. But judges are also capable of undertaking their own legal research, and I think are obligated to do so. But I think we have to be careful, and I think the district courts right now are falling into a trap where they're treating this as almost as though you were proving foreign law. You know, foreign law in courts under conflict of law principles is proven as a fact in court, and they're almost treating it like that and getting historical experts to give affidavits. All this stuff I think is improper. This is fundamentally a legal question, not a factual question, and I think judges have to consult the law just like they would consult the law in any other case.
Professor Smith, do you have any thoughts on that?
Yeah, I would agree with Professor Leider on that. I mean, first of all, the scope of the Second Amendment is really a question of law. We know that from just taking Bruen itself. I mean, the whole decision in Leider versus Bruen was decided based on a pleadings involving a motion to dismiss. So, yeah, I don't think you need real testimony or anything like that on any of these points. But I think the point I'm making in terms of drawing analogies to the criminal trial context is that it doesn't matter why the government is not able to come up with proven that you've committed a crime beyond a reasonable doubt. It doesn't matter. If they fail, they lose. And I think in the context of the Second Amendment, what's happening, Professor Leider kind of referenced this, is what's happening in some of the courts, and I think it's also wrong, is that certain judges are so upset that they are not able to find laws in history to uphold modern gun control laws, that they're throwing a little bit of a hissy fit, and they're threatening to appoint historians as experts. They're trying to bring in historians to testify. None of this is necessary. I completely agree with Professor Leider. This is unnecessary. You would only do this in the context of foreign law, which has nothing to do with interpreting the Second Amendment. And by the way, when these federal judges swear an oath to uphold the Constitution, I hate to remind them, but the Second Amendment is actually part of that oath because it's part of the Constitution. So yeah, I completely agree. This is a question of law. Judges should do their jobs. And as I articulated in my presentation, this is not a very difficult job. The Supreme Court has defined all the key terms. And if the government fails to come forth with historical analogs, too bad, the government loses. We don't cry when the government loses criminal cases. We should not cry when they lose a Second Amendment case, although there are many people in America, especially in urban areas that don't like guns, that do seem to cry when that happens.
So I have another methodological question. One value of originalism, at least in theory, is that it constrains judicial discretion. And some commentators have argued that the history and tradition test wouldn't do that. It's kind of like the law of qualified immunity. The judges can, in theory, slide up and down the scale of generality to find or not to find historical analogs. Do you have any thoughts on that criticism? And we can begin with Professor Smith and then go to Professor Leider.
Well, I think that it's very difficult for a judge to have, discretion to uphold certain gun control laws when they can't find any at the time of our founding to draw an analogy from. So I think it's a lot less likely that you're going to get an abuse of discretion by judges in the context of applying text, history, and tradition. And the big reason why is, what do judges? Judges are lawyers by training, and they're interested in books, they're interested in words, they're interested in reading and interpreting things. It's their entire job, and they've devoted their lives to it. Arguably, that's a reason why the First Amendment gets such robust protection, because judges actually understand words and reading materials and are much more inclined to robustly protect it because they understand it. And in the context of the Second Amendment, I think judges are much more better positioned to read the text of a legal document, in this case, the Second Amendment, to read the legal precedents of the Supreme Court interpreting the Second Amendment, and then to look for historical. And remember, they're not being asked, Jacob, to look for history. They're being asked to look to identify and understand historical laws, right? Historical analogs, i.e. regulatory laws that are enforceable. That is something judges do literally every single day in courts across America. The one thing they do not do is engage in tiers of scrutiny balancing, where you try to use statistics to weigh the pro and the con, the good and the bad of public policy. That's the one thing that courts absolutely do not do. And I think it's much more likely to have an abuse of discretion when they're applying statistical and econometrics analysis than when they're applying text and history of actual laws going all the way back to 200 plus years ago with the Constitution they swore an oath to uphold.
So I think Bruen says you engage in the same method of reasoning that you would engage were you doing anything else. The historical modes of firearm regulation, as I said before, involve police power exercises. And when you look at what courts have done when saying, constitutional or not, they look at the text, they look at the historical tradition, and they reason from the general purposes of what the right is trying to accomplish. And this is how we would do it in any other context. I mean, when we say a categorical ban on child pornography is okay under the First Amendment, where a categorical ban on political speech is not, even though each one targets one narrow type of speech, we are reasoning not just from the text, but also from history and also from the purpose of the right. And so I think on this end, judges are as capable of doing it in the Second Amendment context as they are anywhere else. I think one area I disagree with Professor Smith, I think, is that I don't think they're asking for analogs of specific laws. I think they're asking for analogs of the tradition of regulation, which is why I keep talking about the police. But this is what the 19th century would have called, the police power regulation. It was not just on the Second Amendment. Police power regulated property rights, free speech rights, all kinds of other rights. But there is, I think, a practical answer today, which is that, Are judges going to have problems with this? Yes. And why? Because the gun control issue is so divisive that I think judges are human beings like anyone else. And judges who feel very strongly about this issue will engage in motivated reasoning. And there's just nothing, there is nothing that the Supreme Court can do to stop it. The judges probably can't stop themselves from engaging in it. And so I think, I am skeptical that no matter what tests the court announces, the judges are going to be consistent in how they apply it. I think that's asking for judges to be superhuman. But I also think, and this is also something I should have mentioned in my initial comments, but I'll mention now, I think that for critics of Bruen, there is a double standard being applied to Bruen that is compared to every other kind of right. A lot of the Supreme Court enforcement of other rights did not occur to the 20th century. The Supreme Court did not enforce the First Amendment until really starting in the 1920s. The criminal procedure rights really took off in the 1960s. When the Supreme Court first recognized a right to have counsel provided by the state, it did not set exactly what the right was for all time. There were a series of decisions, starting with you have a right in capital proceedings, and that eventually ended with you have a right anytime a sentence of imprisonment can be imposed. And, it took many years and many decisions to settle the right. And, in the interim, you had lower courts coming to different opinions. And now you have the same situation with the Second Amendment. Heller said, we're not deciding everything. Bruen says, we're not deciding everything. And people are just look askance at the fact that lower courts don't know exactly what to do in every permutation of a Second Amendment case. Well, no kidding. The law has to develop over time. And the Second Amendment will develop over time, just like every other amendment did. It's just that the Second Amendment got a late start.
Great. I want to turn to a question from the audience. So this is directed to Professor Smith, but I think Professor Leider might have insight as well. So you have written, Professor Smith, both that Professor Lash and Professor Amar's arguments for why the 14th Amendment is the relevant time period for the incorporated Second Amendment, right? You claim that they're wrong. You seem to primarily point to precedent to show that this is the correct path and reject the idea that Congress was speaking a new Bill of Rights in the 14th Amendment. This questioner's question is, how do you address without precedent the argument that the Union as it stood in 1791 was destroyed by the Civil War and then reconstituted in the same way that the Constitution destroyed the Articles of Confederation? So I think the question seems to be driving at the fact that you have claimed that the Second Amendment right is the same as applies to the federal government and the states. And this questioner is challenging you on that position.
Well, you can certainly challenge me, but you can't challenge the Supreme Court on this because the Supreme Court has made clear that the Bill of Rights in all respects applies equally to the federal government as it does to the states. That's not Mark Smith's theory. That is actually what the Supreme Court has said. And it makes a lot of sense, obviously, because you really, as a practical matter, cannot have one meaning of the Second Amendment or the First Amendment or any amendments as applied to the federal government and have a different one applied to the states. And that is just not what the Supreme Court has done. And again, if you look at, in my article in the Harvard Journal and in another article in SSRN, if you look at what the Supreme Court has actually done in the context of the Bill of Rights, because remember, it's not just the Second Amendment, it's the whole Bill of Rights, they have basically always looked to the 1791. And when I use that, it's the founding era, right? It doesn't have to be on exactly 1791, but the founding era to understand the scope of that right. And what the 14th Amendment did is it did not rewrite any of the Bill of Rights. It simply took the Bill of Rights that it was understood and applied it to a new class of individuals, in that case, the freed slaves, because of the 13th, 14th, and 15th Amendments. So I think that's what really was going on here. And if you look at the McDonald case in 2000, when, what the Supreme Court was doing there is just saying, look, the 14th Amendment, if it's a fundamental individual right, we're going to apply it to the states. As to the meaning, that is still set in 1791. And again, I don't see anything in the Supreme Court precedents that would suggest that it could be any other way, because if we're truly originalists, the fundamental notion of an originalist, of course, is that you look to the the understanding of the people that adopted it. And there's no other way to look and understand the original public meaning of the Second Amendment or other aspects of the Bill of Rights unless you actually look at the public understanding of the words as they were being adopted in 1791, as well as, you know, any other public understanding that you can derive any other laws or whatnot. But again, it has to be 1791, because if it's 1865 or beyond that, you're literally, you know, decades after the death of the last founder, which was James Madison. And again, you don't have to trust me or agree with what I say. Just look at what the Supreme Court did in 2020 in the Espinoza versus Montana case, where they absolutely rejected no fewer than 30 state laws that said that you couldn't use public funds to support religious schools. In that case, the Blaine Amendments dealt with Catholic schools, and the Supreme Court, with John Roberts writing for it, says, nope, doesn't count. That's not a longstanding tradition that allows us to interpret the First Amendment in a way that narrows the scope of the meaning. So again, don't take my word for it. Just take what the Supreme Court has said in Espinoza and beyond.
Professor Leider, would you like to address this question?
Yes, this is one area where I think I have a methodological difference from Professor Smith. I think you can challenge the Supreme Court on this. The Supreme Court is engaged in a more originalist understanding of the Constitution, and many of the decisions that Professor Smith points to that say you apply them equally did not engage in particularly originalist methodology. And so, you know, I think as we're reevaluating things, this is one area we can reevaluate. And you know, one of the issues is that the Privileges and Immunities Clause does not incorporate the Bill of Rights as such. And the Bill of Rights does not create nationally created rights. The Privileges and Immunities Clause simply gives a federal cause of action to people, you know, whose rights are violated, but those rights are general law rights. And, you know, when you ask what were the, you have to ask, the question is not what did the Bill of Rights mean in 1791? You have to ask, what were the privileges and immunities of citizens of the United States in 1868? Now, it might be the case that the privileges and immunities of citizens of the United States in 1868 were coextensive with, or, you know, if not coextensive with, a subset of those privileges and immunities were the Bill of Rights, were the rights enumerated in the Bill of Rights as they existed in 1791. But that's not automatically the case. I think that requires argument. And I think a lot of, you know, there's been a lot of scholarship recently from, you know, again, Judd Campbell, Will Bode, Steve Sachs, suggesting that, you know, the Privileges and Immunity Clause was not just incorporating the Bill of Rights. What it was doing was incorporating these rights at general law. And I think if that's true, the question is, you know, the question is which general law should apply. And, you know, I think there are, you know, given that the protection against state infringements of rights was in 1868, I think there's a good argument that it should be those general law rights as they were understood at the time that the Privileges and Immunities Clause was adopted, rather than when the general law rights were secured against the federal government in the Bill of Rights. And one final point on the question of why not just interpret this as an entirely new constitution, because the radical Republicans did not blow up the Constitution and create an entirely new constitution. They used the 1789 Constitution and they added a series of amendments that prohibited slavery, that provided a federal cause of action for breach of certain general law rights, and that eventually extended citizenship, extended voting rights regardless of race. And so I think you have to interpret the Constitution as it exists with those amendments, and not in a fictional world where the Constitution was destroyed and a new Constitution was created.
Professor Leider, I'd like to follow up on that question. So the implication from what you just said seems to be that courts would be looking to different evidence in interpreting the Second Amendment versus the 14th Amendment. So to what extent does 19th century practice, even leading up to the 1860s, inform our understanding of the Second Amendment for statutes that apply or that promulgated by the federal government? So in other words, is the same evidence applicable to both, or do you only look at some evidence for the Second Amendment and others for the 14th?
I mean, I think, you know, I think in some ways the dispute's a little bit academic, because I don't think the right to bear arms underwent a profound shift from 1791 to 1868. I think, you know, in 1791, it was at least clear that it was an individual right for military-related purposes. And then you see in the antebellum era this dispute among state courts about whether it was a right for private self-defense against criminal wrongdoing too. And that gets settled by the vast majority of courts as saying, yes, it includes individual self-defense against criminal wrongdoing too. And I think for the framers, that distinction wasn't really a salient one, because bearing arms for the common defense might have also included things like using arms to suppress a forcible and atrocious felony. And for the framers, that would have been an incident of law enforcement by a private citizen. By 1868, that would have been called individual self-defense. So I think, there is some shift. I mean, I think in terms of the evidence, I don't think there would have been much. It's hard to say, because they would not have recognized any national power to regulate guns apart from the militia clauses. The modern expansive Commerce Clause jurisdiction didn't exist. The only place that the federal government could have exercised any sort of police power would have been the territories and the District of Columbia. And I think, I think you can borrow from the subsequent case law going back to the 1791 just to ask questions like, can the federal government prohibit carrying concealed weapons in the District of Columbia as a regulation of the right? But I don't think, I think what happened between 1791 and 1868 isn't so much regulation consistent with the right or inconsistent, but there's also this third category of there's a lot of open questions that we just haven't answered because the English Bill of Rights was not enforceable in court against Parliament. And so there wasn't a lot of judicial precedent on this. And I think a lot of precedent just developed over time. And I don't think there's any reason in principle why you can't apply the precedent that develops against the federal government just like you can against the states. But I think, I'm kind of ducking the question a little bit, but I think that's in part because the right to bear arms just doesn't undergo that profound a change between 1791 and 1868.
So I'm going to close with one last question that is somewhat methodological, but also practical. Some critics of the history and tradition test point out that it creates some unseemly results. For example, Professor Winkler has talked about the potentially racially disproportionate effects of this approach. In the Rahimi case recently, the Fifth Circuit struck down a statute prohibiting adjudicated domestic abusers from keeping arms. What is your response to critics who say that this approach creates unseemly results in a way that the tiers of scrutiny approach did not? And we can begin with Professor Smith and then go to Professor Leider.
Well, I think the Supreme Court actually already addressed this in the McDonald case, where they were discussing that, for example, the criminal procedural aspects of the Bill of Rights allow criminals to sometimes go free, right? The Fourth Amendment's, right against unreasonable searches and seizures, the Fifth Amendment's right not to incriminate, the fruits of the forbidden tree, and the suppression rules in criminal cases. These are instances where we bend over backwards to protect the innocent, and the result of that is occasionally people that are bad, who should be in prison, escape. Now, with respect to the Rahimi case, keep in mind that he, at least as I understand the record, had not actually been convicted of any crime at the time the sort of mutually agreed to restraining order in the context of a civil case, was entered. And that, I think, is the major argument in the Rahimi case, that you can see Judge Ho down there in Fifth Circuit saying, look, Rahimi may be a bad dude, but at the time the restraining order was entered, he had not been convicted of a crime, and he was not represented by counsel when they entered a generic restraining order, and he basically agreed to it. And that is not enough to lose your right to keep and bear arms under American law, because at first and foremost, you got to be convicted of something and be deemed dangerous. That was the historical standard, and Rahimi just didn't meet it. And I think Judge Ho's concurrence in Rahimi was quite persuasive.
Professor Leider.
I think I think that the framers of the 14th Amendment thought that it was pretty clear, a lot of them thought that the right to bear arms was among the fundamental rights of citizenship, and it was extraordinarily important to extend these rights to the freedmen. So I don't think, just because the right was regulable under the police power doesn't mean it has to be regulable in a way that is racially disparate. And I think what's happening now in the lower courts is a lot of intellectual laziness where, people are just trying to point to some analog, often of a racially discriminatory statute or statute that discriminated on religion, say, this stands for the general proposition that you can disarm anyone who's dangerous, and use that as to basically backdoor their way into Justice Breyer's dissent in Heller, saying that every modern gun control law passes muster because you can just disarm anyone who's dangerous. And I think, what needs to happen is that people need to be a little bit more critical about what these laws are. Some of them, like the loyalty oaths around the revolution, are exercises of the war power during a civil war that have no application in peacetime, or might only have application in peacetime in cases of rebellion. Others involve questions of when you can legitimately exercise the police power. And some laws, were very broad, and then the way that local authorities dealt with them was to enforce them in a discriminatory manner. And so I think you have to be suspicious of general bans on public carry. Some were even-handedly enforced, many were not. And so I think what's going on is that people are treated. I think the fundamental problem is that people are treating the Bruen test as go find a law, a specific law that was analogous. And that is not, I don't think that's the correct interpretation of what Bruen says. I think Bruen is looking to the regulatory tradition. I think the regulatory tradition is one of having a police power that regulates rights. And I think the court, whether it uses this language or not, will eventually have to immerse itself in how the police power regulates rights. It regulates the Second Amendment, it regulates the First Amendment, it regulates property rights. And I think the court will have to get there eventually. And until it does, I think you will have these sort of strange analogies that shouldn't really fit while district courts are trying to find an exact. My last thought, it's very hard to find an exact statute because there just wasn't that much regulation of arms at the framing. I mean, that's just kind of the bottom line.
I just want to say that proves my point. The fact that there wasn't any regulation at the time of the founding in and of itself demonstrates the point that most of these modern day firearm laws are unconstitutional. And, Professor Leider does a good job talking about the general police powers. But the Supreme Court in Bruen and Heller was much clearer than that. They specifically, and again, I go back to the holding of the case itself, where they say that the government's burden is to establish or to show, quote, modern day gun control laws are, quote, consistent with the nation's historical tradition of firearm regulation, which means that they actually have to come forth with multiple examples of that kind of regulation, because you need more than one example for there to be a tradition, I would argue. There has to be a series of actual historical analog laws at the time of our founding that give rise to that tradition. And if you don't have that historical tradition because there's not enough examples of enough laws, it's game over. It's not a question of, in theory, could a state police power somehow regulate it? It's irrelevant under the Leider versus Bruen test. The question is, did it actually occur? Was it part of the nation's historical tradition of these regulations? And regulations obviously mean you actually have enacted a law that's enforceable and was enforced. And if you didn't have that and the government can't show that, they lose. And we shouldn't cry about it any more than we don't cry about it when the government loses a criminal case. The government should not, when in doubt, the government should lose and freedom should prevail. That is the fundamental point of the Constitution, to protect our freedoms and liberties against an overreaching federal and state set of governments.
I think you have to unmute.
Sorry, it appears that we've reached the end of our time here, and I want to thank both panelists and our attendees for joining us. Thank you.
Thank you.
Thank you.